Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as I see a few people down there in Las Vegas, and of course, anyone watching online through Nellis or our legislative YouTube channel. And with that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orenlicker, Roth, Urick, Chair Miller.
Here. And please mark Assembly Member Gray and Moore present when they arrive, and Assembly Member Hardy absent excused. And if Assembly Member Gonzalez arrives, mark her present as well. And so with that, just a few reminders, please everyone turn off your electronic devices. Also, we will have public comment at the end of today's meeting. The phone number is 1-888-475-4499. That's for anyone wishing to call in to testify on any of our bills or to make public comment today. If you're calling, the member ID is 885-840-64317 today. With that, we ask that anyone presenting a bill keep their presentation to 15 minutes, and those making public comment or testifying on the bill, keep your comments to 2 minutes, please. We, of course, will remind you if you forget to state your name and also to spell it for the record the first time that you speak so that we have it accurate. We do have 3 bills today, and we will go ahead and take them in order of the agenda. So the first bill we will hear today will be Senate Bill 4, which revises provisions relating to consent to adoption. And with that, the hearing for Senate Bill 4 is open. So I'll give you a few moments to get settled, and then whenever you're ready, please proceed.
Good morning. Good morning, Chair Miller and members of the committee. My name is Betsy Crumrine. I'm the Deputy Administrator for Child Welfare for the Division of Child and Family Services. I'm here today to address an issue that has delayed adoptions in the foster care system for the Division's Rural Child Welfare Program. Several years ago, the Division began hiring caseworkers with related degrees as a way to fill high social worker vacancy rates in rural areas. This practice aligned with the urban counties who have broadened the qualifications of staff who qualify to work in the child welfare field. Existing law, NRS 127.053, requires 2 disinterested parties must witness a consent to adoption, and one of those witnesses must be a social worker. Having the requirement that only a social worker can witness a consent to adopt is proving to be a hardship for the division given the number of small offices in rural areas. Section 1 of this bill proposes to amend NRS 127.053 to allow for a social worker or a caseworker employed by one of the authorized agencies under the law to witness a consent to adoption. Most states do not specify a specific job classification or title who can witness a consent. Terms used nationally include licensed child placing agency, agency who has custody, adoption provider, adoption facilitator, etc. For Nevada, the division is requesting to extend to caseworkers and did not expand to agency or another agency term. We kept it narrow as we believe it's still a function of a caseworker or social worker. As noted in my opening comments, the consequences of not adopting SB4 are that adoptions may be delayed as we may not have a social worker in a rural office to witness a consent at the moment a parent decides to consent. Having to schedule a consent and track down a parent to come in at a later time could delay permanency for children by several months. This will also assist in smaller offices where the agency must provide a witness that has not had any prior contact in the case, which includes removal, emergency on-call, consultation, etc., thereby further limiting the pool in rural offices that have minimal staff. I'm available for any questions if you have them.
Thank you so much. Let's see, at this time, I do not see any questions.
Thank you.
You're welcome. So I will go ahead and open it up for testimony in support. We'll start here in Carson City. Anyone wishing to testify in support?
Good morning, Chair Miller, members of the committee, Joanna Jacob, JACOB, on behalf of Clark County, here in support of SB4. And I just saw my colleague Cadence Matievich from Washoe County. We are doing double duty with government affairs this morning, so I would also like to put the support of Washoe County in support. And her last name, I'm going to try it, is Matijevich, Cadence Matievich from Washoe County, Joanna Jacob for Clark County. We are in support of the bill. Thank you.
Thank you so much. And I'm going to ask her when I see her, but just, we trust you. Thank you. Is there anyone else here in Carson City? Is there anyone there in Las Vegas that would like to testify in support? Not seeing any. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers at this time.
Thank you so much. I will go ahead and open it up for testimony in opposition. Is there anyone here in Carson City that would like to testify in opposition? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the lines, please?
Chair, the public lines are open and working. There are no callers to testify in opposition at this time.
Okay, thank you. Then I will open it up for testimony in neutral. Is there anyone here in Carson that would like to testify in neutral? Anyone in Las Vegas? Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no callers for neutral at this time.
Thank you so much. Then with that, I will ask the presenter any final remarks. Okay, thank you so much. Then I will go ahead and close the bill hearing on Senate Bill 4. Not sure if that beat our record from yesterday, but I'm going to go back and time it later. So with that, I will open up the hearing for Senate Bill 26. Senate Bill 26 revises provisions authorizing certain entities to obtain information relating to the records of criminal history of, my 2 minutes are up, of certain persons responsible for the safety and well-being of children, elderly persons, and persons with disabilities. So again, I will also give you a few moments to settle in, and then whenever you're ready, please state your name and spell it for the record, and of course, proceed when you're ready.
Thank you. Good morning, Chair Miller and members of the Assembly Judiciary. For the record, I'm Erica Souzayamas, ERICASOUZA-LLAMAS. I'm the Administrator for the Records, Communications, and Compliance Division within the Department of Public Safety. The division houses the Central Repository for Nevada Records of Criminal History, which maintains statewide records of Nevada arrests and dispositions, and is also responsible for processing fingerprint-based background checks for licensing, employment, and volunteer purposes, which have legislative and federal authority. With me today, I have Georgina Castaneda, and she's one of our Special Services Managers. She's here today to present Senate Bill 26 to the committee. This bill amends NRS 179A to slightly broaden fingerprint-based background checks conducted under the National Child Protection Act, Volunteers for Children Act, otherwise known as the NCPA-VCA. I'll now turn it over to Georgina to present the bill.
Good morning. For the record, I'm Georgina Castaneda, GeorginaCastaneda, Management Analyst within the Department of Public Safety, Records, Communication, and Compliance Division, and I am here today to present Senate Bill 26 to the committee. This bill is proposed to ensure the continuation of fingerprint-based background checks for individuals working or volunteering with our state's most vulnerable populations, children, elderly, and individuals with disability. This requirement extends beyond employees and volunteers to include contractors and vendors who provide essential services to these populations. Currently, background checks are conducted under the National Child Protection Act, Volunteers for Children Act, and CPA-VCA, a federal authority that allows qualified entities to submit fingerprint-based background checks to the FBI. Nevada added the capability to be able to continue using the NCPA VCA backgrounds under the state authority of NRS 179A 325. Originally, the federal authority permitted checks for employees, volunteers, contractors, and vendors with unsupervised access to children, elderly, and individuals with disabilities. However, the Child Protection Improvement Act of 2018, CPIA, extended the law by replacing the term provider with covered individual, which is defined as an individual who has, seeks to have, or may have access to children, the elderly, or individuals with disability served by a qualified entity, and B, who is employed by or volunteers with or seeks to be employed by or volunteer with a qualified entity, or owns or operates or seeks to own or operate a qualified entity. The CPIA broadened background check eligibility to individuals with both supervised and unsupervised access to children, elderly, and individuals with disabilities. It also inadvertently created challenges and lacked the authority to conduct background checks on contractors and vendors of a qualified entity who are neither employed by, volunteering with, or owning or operating a qualified entity under the NCPA VCA. Nevada law does not explicitly authorize background checks for contractors or vendors. Amending the statute to add the authority specific to contractors and vendors will authorize these fingerprint-based background checks. Without this, it creates a significant gap in ensuring the safety of vulnerable populations. For example, a qualified entity in Nevada may hire janitorial, cafeteria, or transportation staff through a contractor. However, under current state law, these individuals cannot undergo fingerprint-based background checks through the NCPA VCA process. The Records, Communications, and Compliance Division currently supports 315 active qualified entities that utilize the NCPA VCA process. In 2023, there were 12,837 fingerprint submissions under this authority, and in 2024, there were 13,018 fingerprint submissions. In summary, to close this gap, Senate Bill 26 seeks to establish statutory authority that allows Nevada qualified entities to continue to fingerprint, background check contracted personnel and vendors under NCPA VCA. Passing this bill will ensure that all individuals working with Nevada's most vulnerable populations, whether employees, volunteers, contractors, or vendors, are properly screened, which will enhance safety, security across the state. This concludes Senate Bill 26, and we welcome any questions you may have. Thank you.
Thank you so much. I don't have a question right now, but I say that we appreciate making sure that everyone that comes into contact with our most vulnerable are, we're just aware and making sure we're doing the most to protect individuals as much as possible. I don't see any questions right now. So with that, I will go ahead and open it up for testimony. Anyone here in Carson City, thank you, wishing to testify in support of Senate Bill 26?
My name is Maximilian Lowe, Maxmillian. My last name is Lowe, Lowe. I'm here to support this bill because as a person who receives services, I believe that this is a great step forward to know that those who work with the vulnerable populations are being safe, as current law is that there's some issues that have gone on that I have experienced, and I have friends who receive services that had some negative issues that I believe this bill will cover, and I thank you some more and support the bill. Thank you.
Chair Miller, members of the committee, my name is Susan Keema, Keema. I am the Executive Director for the Nevada Association of School Superintendents, and we are testifying in support of SB 26. Thank you for your work on this bill.
Thank you so much. Is there anyone else here in support? Not seeing anyone. Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers to testify in support at this time.
Thank you. With that, then I will open it up for testimony in opposition. Is there anyone that would like to oppose Senate Bill 26? Not seeing anyone here in Carson City or Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers to testify in opposition at this time.
Thank you. Is there anyone that wishes to testify in neutral? Not seeing anyone here in Carson or Las Vegas. Broadcasting, will you open the lines, please?
Chair, the public lines are open and working. There are no callers to testify in neutral at this time.
Thank you so much. Would the bill sponsors like to also don't want to make any final remarks? Okay, thank you. So I will go ahead and close the hearing on Senate Bill 26. Wow, I can say so far, second house is a breeze. So far. So with that, I will open up our last hearing today for Senate Bill 409. Senate Bill 409 revises provisions relating to the reporting and investigation of child abuse or neglect. And with that, whenever you're ready, please proceed.
Good morning, Chair Miller. Joanna Jacob, JACOB, on behalf of Clark County. I hope that we will continue the trend and this will continue to be a breeze. Happy to be in the second house with my colleague Amity Latham from our Clark County District Attorney's Office down south. So she is ready to go. Just to, by way of introduction, Senate Bill 409 was a bill that we presented to the Joint Interim Healthcare, the Standing Committee on Healthcare, over this past summer. And I will hand it over to Ms. Latham for her statement in support and presentation on the bill. Thank you.
Good morning, Chair Miller. My name is Amity Latham, Latham. I'm a Chief Deputy District Attorney working in the DA's office, and I practice in the area of child welfare. In child welfare, we're responsible for ensuring children are safe from abuse and neglect. Children who are injured by their parents or caretakers need appropriate medical care, and they need medical opinions. Often these medical opinions are relied on to determine whether a child needs protection because injuries are inflicted and non-accidental, or sometimes they can be due to some other medical condition. Either way, these opinions are relied on in court to give the judge a full picture of the child's medical condition and injuries. Additionally, when a criminal prosecution for the abuse or neglect of a child requires the same medical, often requires the same medical information from these professionals. However, some medical professionals are reluctant to provide opinions because of potential liability. So in Nevada, there's a lack of providers willing to give these opinions and to specialize in child abuse. So Senate Bill 409 would work to address these concerns, but even more importantly, bring Nevada in line with the Child Abuse Prevention and Treatment Act as it was amended by the Victims of Child Abuse Reauthorization Act of 2018. Globally, that CAPTA requires states to have immunity from civil or criminal liability for individuals making good faith reports of suspected or known instances of child abuse or neglect, and who otherwise provide information or assistance, including medical evaluations in connection with the report, investigation, or legal intervention pursuant to a report. And in Nevada, since 1985, we've done that through NRS 432B-160. However, current federal law offers something Nevada does not. It offers that under federal law, if a defendant prevails in a federal civil action, the court may award costs and reasonable attorney's fees incurred by that defendant. Senate Bill 409 proposes to add a version of this protection into Nevada state law by extending it not to any defendant, as the federal law does, but only to mandated reporters. This should significantly help medical professionals to feel more comfortable in rendering opinions regarding the abuse or neglect of children. Nevada has protected mandated reporters of abuse or neglect for over 40 years. In 1987, Nevada amended NRS 432B160 to add a provision that if there were a proceeding to impose liability against a mandated reporter, there would be a presumption that the report of abuse or neglect was made in good faith. Nevada did that in 1987. Again, this matches the federal protection language found in CAPTA. Senate Bill 409 would add the final piece to Nevada statute that CAPTA already has, but we do not have, in that if there was a suit of this nature, a lawsuit of this nature, if a mandated reporter were to prevail, they could ask the court for reasonable attorney's fees and costs. And with that, I can answer any questions if you have any.
Okay, I don't see any member questions at this point, but could you give an example of maybe when this has happened, these types of situations, or what could possibly happen? Just give us an example.
So what happens is let's say a child is injured by their parent or caretaker. We would need, in order to remove that child or maybe the other children from the home, we would need a medical provider to give an opinion whether the injury occurred as a result of abuse or neglect. There are some medical conditions that could cause injuries that may mimic the abuse or neglect of children. So we, as lawyers, we don't know, and as judges, we don't know. We rely on medical opinions. Sometimes, as we know, medical providers and other people face liability or lawsuits. So maybe a medical provider gives an opinion and they are later sued for that opinion. Nevada law currently indicates that it's presumed that they made the report or assisted in the evaluation of that child in good faith. However, sometimes even with all these protections, they're still subject to lawsuits, and sometimes they are not lawsuits that are meritorious, and yet they're still subjected to hiring an attorney to defend a lawsuit that is not meritorious. CAPTA allows that defendant to ask the court to reimburse, to have the person who sued them pay their attorney's fees and reasonable costs. So that would be, we would be asking Nevada to add the same statutory language, which if they are sued and they hire a lawyer and they incur certain costs related to hiring the lawyer and defending the lawsuit, if they are meritorious, they could then ask the Nevada court that the plaintiff pay their reasonable attorney's fees and costs. I don't know if I answered your question or if that made sense.
Yes, it did. It did clarify that. Thank you.
And Chair Miller, Joanna Jacob, for the record, I just wanted to clarify for the record, that was Amity Latham, Latham, on behalf of the Clark County District Attorney's Office, responding to that question. Thank you.
Thank you so much. I still don't see any additional questions, so with that, I will go ahead and open it up for testimony. Beginning here in Carson City, anyone that would like to testify in support of Senate Bill 409.
This is Maximilian Lowe for the record again. I do support this bill because it would help those who make determinations, medical providers who make determinations on child abuse and neglect cases that make good faith, to protect them if they incur a lawsuit. And as the presenter said, that currently only the federal government, federal CAPTA thing has it. So I believe that this would be a good step forward for Nevada and Nevada's child welfare system. Thank you.
Thank you so much. Anyone else here in Carson City? Not seeing anyone? Is there anyone there in Las Vegas that would like to testify? Also not seeing anyone broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers to testify in support at this time.
Thank you. Is there anyone that would like to testify in opposition here in Carson City? There's also no one here in Carson or in Las Vegas, so broadcasting, will you please open the lines?
Chair, the public lines are open and working. There are no callers to testify in opposition at this time.
Thank you. Is there anyone that would like to testify in neutral? Not seeing anyone here in Carson or Las Vegas, broadcasting, will you open the lines?
The public lines are open and working. There are no callers to testify neutral at this time.
Thank you so much. Then I will welcome the bill presenters, and they are waiving. There are no final comments. So with that, I will go ahead and close the hearing on Senate Bill 409. With that, the last order of business we have today is public comment. Is there anyone here in Carson City that would like to make public comment? Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers at this time.
Thank you so much. Well, with that, we have beat our 35-minute record. I think we're at about 27 minutes for 3 bills. I will go ahead and adjourn this meeting. Hopefully, everyone has a great week, and I will see you back Monday morning at 9 a.m.